Good morning. So I will talk about the purpose and the functioning of EU law in the context of our discussion on the revision of the Clinical Trials Directive into the Clinical Trials Regulation. So to give you a context, I thought it would be useful to give you the legal background on which this discussion is set, because the EU is a community of law. And so everything the EU does must have a legal basis, and this legal basis can be found in the EU treaty and the so-called Lisbon Treaty, which created much controversy a few years ago. I'm sure you all remember. So there are two articles which I think lay down the objective of the EU in the field of public health that is and pharmaceutical. One is Article 9. Because it lays down public health as an overarching objective of all EU policy and action. The second one is Article 26, which provides that the EU shall take measures to establish a functioning single market. And this is important because industries, including pharmaceutical companies, operate throughout the EU. So they're part of the internal market. So then we go, so these are the objectives of the EU in the field of public health. Now we go into the functioning of EU action in public health. And these are set by Article 168, which provides for the EU to intervene to facilitate the cooperation of member states to ensure public health across the EU, but also the single market. And there, the Commission can have measures to encourage cooperation, set guidelines, recommendation, but it cannot dictate member states what their national health policies or national health law should be. However, if the European Parliament and the Council, which are the EU's legislators, so decide, they can agree that a number of measures are needed to achieve high standards of quality and safety for medicinal products and devices for medical uses. But so then it's not the Commission which initiates, it's the Parliament and Council. Then there is Article 114, which provides for the approximation or harmonization of EU law if it is necessary to ensure a functioning single market. So again, we are here talking about pharmaceutical companies carrying out these trials as a part of the internal market. So then we go to the process, the actual practical process. So there the Commission would first start, if it sees a problem, would first start by drafting and adopting a white paper. Then there would be some discussion. Then they would produce a green paper, which would go for consultation of stakeholders. And by stakeholders there, it would be, in this particular case of the Clinical Trials Directive and Regulation, it would be patient group, industries, national policymakers, I guess companies performing the test. Then, based on the responses to that consultation, the Commission will then produce a draft law, which it will then present to the Council and the European Parliament for discussion, amendment, and then eventual adoption. It can, depending on the problem or what it seeks to address or what it seeks to achieve, it has three legal tools. One is the regulation, one is the directive, and one is the decision. So I will give a brief description of the three because they have different effects nationally and different implications. So the regulation are directly implementable in the nationally. So you have what the EU proposes as a law will be directly transposed nationally and applicable completely, and it will enter into force. I think it's 20 days after publication in the official journal. Also, it is used because the reason it is directly implemented in national law is that there is usually a problem with different interpretation at national level, which creates then problem for achieving the objective. And when that happens, that's usually when the Commission proposes a regulation. They apply to private persons. So in that case, for instance, the companies doing the trials, or the institution, the member states and the institutions. The directive is as I just mentioned, is not directly implementable. So for it to enter into, I'll start again. So the directive only lay down the objective of what member states should be done and for what purpose. So they set out the objective, but they lay some freedom to legislators as to what measures are to be taken to achieve that objective. And in general, it's because EU member states have different legal system, and so there needs to be some adaptation. But still, they must ensure that there's legal clarity and legal certainty. There's a deadline for transposition. Also, when a regulation derives from the directive, the objective cannot change. So in this case, the objective that was set out in the clinical trial directive will remain the same in the regulation. You couldn't have an objective different in the regulation than in the directive. And it confers right to individual citizens as opposed to the regulation, which means that an individual directly affected may claim compensation from a member state for incorrect transposition of a directive, since the member state is responsible for the transposition. You see the difference. And so the individual that is directly affected must go to a national court if it's an incident. Now, if there is a systemic problem of transposition, either non-transposition or incorrect transposition, then you could bring, say, a group of citizens directly affected could bring a complaint to the Commission, asking the Commission to investigate the matter. What would happen then is that the Commission would look into the matter, would ask questions to the member state or to the institution, and then would either ask the member state to correct what is going wrong or to provide clarification of what is happening. And based on this, there will be a back and forth between the member state and the Commission. If the member state fails to take action, and there is indeed a problem of incorrect transposition of the directive, the Commission may take that member state to the European Court of Justice. And if the member state loses, it could face sanctions. So decisions, which is the third legal instrument, is only applies to very specific cases. And we won't talk too much about it because in this case, the two legal instruments that were most relevant were the directive and the regulation. Under there are two other acts which are important to note, is that they are also delegated and implementing act. So the delegated act are used. They're non-legislative documents. So they're not adopted. So delegated act are not adopted through legislative procedure. So they could be an issue, you could say, of democratic accountability. But there are some tools to ensure some accountability. But the purpose of the delegated act is to supplement or amend non-essential parts of the legislative act. But at the same time, the Parliament and the Council, when the directive or regulation is being negotiated, can say, no, we think that having a delegated act on this by the Commission is beyond what we need, and then the Commission would have to take this into account and revise its draft. And then you have implementing acts. which the Commission may think it's necessary to adopt to ensure that the regulation directive is properly operationalized. But the implementing act are usually specified in the regulation. So where are we now with so now the Commission has proposed the draft legislation last year in 2012. So, and it presented the draft to Council and to Parliament. So in Council, the discussion is led by the EU presidency. At the moment, it's Ireland. And it goes through the relevant working group, which is composed of member state technical experts, which go through the different articles of the law. And gradually it goes to the more political level, up the echelons of the working groups, until it reaches the thematic councils of member states and ministers. The text is also discussed in Parliament. A rapporteur is appointed by the Parliament to draft a report on the proposed legislation. It's not actually a report as the other reports of the Parliament, because it's actually amendments to the Commission proposal. So on the report, that's how the report looks like. On the left-hand side, you have the Commission, the articles proposed by the Commission in its proposal, and on the right-hand side, you have the Commission proposal plus in bold the amendments put forward by the members of the European Parliament. And then you have a negotiation between the rapporteur, but also the shadow rapporteurs, which are appointed by each political groups in a way to provide input and to ensure that the proposal also goes in the direction of the other political groups. But then in addition to political groups, you have also national interests. So one member state might have a different interest than another member state, and MEPs from a same political group from different countries might have different interests. So there is also a negotiation that can happen. And this is where the crux of the lobbying and advocacy activities take part. That's why you have so many companies, like pharmaceutical companies and others, public affairs companies, NGOs, professional association based in Brussels to actually influence the amendments in the way they're proceeded, but also to take part in contributing to the drafting of the consultation paper, the green paper, sometimes to lobby for even a green paper, which then will lead to legislation. They take part in the consultation, then they take part in they try to influence the Commission when it drafts the proposal. Then they get in touch with the member state to push certain amendments, and also then you also have the active lobbying at the European Parliament level, because in the end the Parliament, even though in that area, is a co-legislator, so the Parliament can accept, amend, or reject the content of a European legislation. So, and then let's say everything goes well. It can be a very long process of back and forth, and the Parliament rapporteur usually also meets with member state working groups to progressively go into the same direction. Once the Parliament has more or less agreed on the text, it is adopted in committee, and then it will be adopted in the plenary session. So you have a whole series of readings in committee with amendments, then first written amendments, then oral amendments, which you make during the committee session or the plenary. So let's say the text is adopted both by the Parliament and the Council. The role of the Commission is to verify that the law is correctly implemented at national level, because the Commission's role is to be the guardian of the treaty. So it can take formal action against a member state if it deems that it violates, or an institution if it violates EU law, and it can impose sanction on individuals and companies who violate EU law. So what does it mean for the European AIDS Treatment Group and Patient Group involved in clinical trials discussion. So ideally, as a patient group, we would be involved from the first stage of the legislative process, from the discussion on the orientation of an EU measures to the actual end and implementation. So where are we now? We are at the stage where the text is in the Parliament. So what can we do as a patient group? We can look at what our interests is or what our concerns are as patient taking part in clinical trials, reviewing protocols, being involved in or trying to get involved in ethics committee, and see whether the text proposed by the European Commission actually responds to these concerns. That's one thing. The other thing is looking at whether, besides what our concerns are, whether we think the text is counterproductive in other fields which are related to what we do. And this is what will be discussed in the next session with Lital Hollander, who's drafting the position paper of the European AIDS Treatment Group on the revision of the Clinical Trials Directive into a regulation. So we can propose amendments, very concrete text, and then get in touch with the different MEPs to hope that they will be integrated in the written amendments. If that doesn't go through, we could try at a later stage with oral amendments, but that's more difficult. And we should really push at this stage for limited numbers of amendments, because then our message will be clearer. The next stage, when the legislation is adopted, and I think patient group have an important role in monitoring the implementation of the regulation, notifying the Commission and other groups in other countries about problems in clinical trials and how they're happening in country in comparison to whether the regulation is correctly implemented, and whether it has negative side effects, unforeseen side effect, or effects which we had suspected but which were still theoretical. So there, patient groups have an important role in monitoring the implementation and speaking up when things go wrong, and maybe because some trials happen in different countries, there will be a need for patient group from one country to talk with patient group from another countries, to see maybe that common actions can be taken or notified. Also maybe sometimes work when needed with associations working at European level, because you need to address both the national and the European level.